Before the team from Japan holds its mock trial, I will introduce the members of the panel. Playing the presiding judge is Masatoshi Miyazaki, who is the presiding judge of the Intellectual Property High Court. Playing the associate judges are Hiroyuki Motoyoshi, who is a judge of the Intellectual Property High Court, and Kenji Amano, who is also a judge of the Intellectual Property High Court. Playing the attorney for the plaintiff is Takamitsu Shigetomi, who is an attorney at law at the Or Ebashi LPC and Partners law firm. Playing the attorney for the defendant is patent attorney Kaoru Kuroda, who is an attorney at law at the Abe Ikubo and Katayama law firm. Playing the role of a judicial research official is Naoko Matsumoto, who is a judicial research official at the Intellectual Property High Court. Playing the role of a technical advisor is Kenshi Takanaka, who is also a judicial research official at the Intellectual Property High Court. The narrator is Ken Asai from the Intellectual Property High Court. Thank you. Please go ahead. The normal flow for a patent infringement lawsuit is as follows. At the first date for oral argument, after submission of the complaint and reply brief, which are usually prepared in document form, a video conference is held to officially confirm the points of issue and evidence in preparatory proceedings through the dates for preparatory proceedings or documentation. Subsequently, the process returns to the dates for oral argument and the procedures are carried out until the rendering of judgment. This mock trial consists of the second date for oral argument, on which an explanatory session is held, and the third date for oral argument on which the judgment is rendered. The second date for oral argument was held on September 17th. In addition to the judge and parties to the lawsuit, this date is attended by technical advisors and judicial research officials. In addition to formally confirming the arguments to be presented and the evidence of the case, an explanatory session is held to describe the technical matters pertaining to the points of issue. Technical advisors are part-time court personnel designated depending on the case from a pool of university professors or researchers from public or private institutions. The role of technical advisors is to explain specialized and technical matters pertaining to points of issue to the court. The judicial research officials are full-time court personnel who are ordered by the court to investigate the necessary technical matters. In this case, one technical advisor and one judicial research official will contribute to the proceedings alongside the judge. This case has already used a video conference system, which allows both parties to send and receive video images and sound without having to attend the court in person to officially confirm the points of issue. Therefore, this date for oral argument consists of a statement on the outcome. This mock trial is based on the officially confirmed arguments and evidence. We will summarize the arguments presented by the parties and describe the technical matters pertaining to the case as explained by the technical advisor. On this date, the technical advisor will join the mock trial via the video conference system. Under current procedures, the technical advisors actually attend the court in person to participate in the explanatory sessions on the dates for oral argument. However, in this mock trial, to showcase the digitization of Japan's judicial procedures, we would like to demonstrate a possible scenario for the proceedings of the future. Now, let us commence the explanatory session. After clarifying the points of issue, the point at issue in this case is the applicability of international exhaustion, more specifically, Collie Corporation, which has obtained a license for the corresponding patent right from the plaintiff, Pony Corporation, has exercised the corresponding patent right by producing and selling the plaintiff's roll paper within country B. However, the defendant, Donkey Corporation, is importing the defendant's products, which are produced using the core tubes of the plaintiff's roll paper, from country B to country A, and selling them within country A. The issue at hand pertains to whether the exercise of the patent right is not entitled due to exhaustion. Based on this point of issue, we will summarize the arguments of both parties and explain the technical matters. So, I'd like to call on the attorney for the plaintiff to make their argument. Now, I, the attorney for the plaintiff, Pony Corporation, will present a summary of the plaintiff's arguments and explain the relevant technical matters. First, as a legal argument, the concept of international exhaustion is not applicable. Second, the actions of the defendant should be regarded as a novel production of a patented product, and therefore exhaustion should be denied. About point 1, under the Patent Act, even if domestic exhaustion is authorized, this does not mean that international exhaustion must be. This is because, in this case, if the patent right held by the plaintiff in country A and the corresponding patent right in country B are shown to be separate rights, then the plaintiff has exercised the patent right for products relating to the corresponding patent right in country A, and it cannot be regarded as profiting twice. I will also address point 2. The limitation on the exercise of the patent right through exhaustion only applies exclusively to the original patented product itself that has been assigned by the patent holder or its equivalent outside the country where the patent is granted. Therefore, when a patented product that was assigned outside the country by the patent holder or its equivalent is modified or a component replaced, resulting in novel production of the patented product that is not identical to the original patented product, the patent holder is entitled to exercise the patent right for that newly produced patented product. In this case, the plaintiff's roll paper is exclusively used for packaging articles. The packaging sheet of the plaintiff's roll paper is a major part of the product and also holds concentrated economic value. In addition, it cannot be assumed that the user would rewind packaging sheets onto used core tubes, and the core tubes have no value to the user. Therefore, after the packaging sheet has been used up, the utility of the plaintiff's roll paper as a product is completely lost. Therefore, rewinding the packaging sheet should not be seen as a replacement of a consumable component. However, obviously it is not impossible to reuse the core tubes. However, although the core tube of the plaintiff's roll paper is required to fit the patent's device to a high degree of accuracy, it is designed to be used up entirely once attached to the plaintiff's device, and does not have a structure and strength suitable for removal. When cycling and reusing the core tube, it is difficult to ensure the quality of the roll paper. Therefore, when the packaging sheet of the plaintiff's roll paper is consumed, its utility as a product is lost. Winding a new packaging sheet onto the core tube of the plaintiff's roll paper causes it to lose identity as a product and results in the novel production of a patented product that is not identical to the plaintiff's roll paper. Thank you. Next, I'd like to call on the attorney for the defendant to make their argument. Now, I, the attorney for the defendant, Donkey Corporation, will present a summary of the defendant's argument and explain the technical matters. First, as a legal argument, the concept of international exhaustion is applicable. Second, the actions of the defendant should not be regarded as a novel production of a patented product, and therefore exhaustion should be authorized. First, for point 1. When a patent holder or its equivalent has assigned a patented product outside the country where the patent was granted, the patent holder should not be entitled to exercise the patent right over the assigned patented product unless 1. The patent holder or its equivalent have agreed with the assignee to exclude the country where the patent was granted from the areas of sale of use of the patented product, or 2. In the case of a third party who has acquired the patented product from the assignee of its subsequent assignees, an agreement as above has been made with the assignee and it has been explicitly indicated on the patented product. With respect to this point, there is no indication on the plaintiff's roll paper that country A is excluded from the areas of sale of use. Therefore, the plaintiff should not be entitled to exercise the patent rights in country A for the defendant's product. Next, point 2. Since the defendant's product is manufactured by rewinding a packaging sheet onto a used cold tube of the plaintiff's roll paper after the packaging sheet has been consumed, the core tube of the plaintiff's roll paper is being reused without modification. Furthermore, the packaging sheet of the roll paper is also consumed in the course of normal use. Therefore, no modification or component replacement is applied to either the core tube or the packaging sheet of the plaintiff's roll paper. Fundamentally, the distinctive technical aspect of the invention lies in the provision of magnets in the core tube of the roll paper and the fact that the rotational angle of the roll paper is detected by a rotation angle sensor. In addition, the core tube of the plaintiff's roll paper is made of hard plastic and does not suffer damage or deterioration within the time frame required to consume the original packaging sheet. Therefore, regarding the reuse of the core tube, it cannot be argued that the patented product is being reused after its ordinary life as a product has elapsed. Moreover, the packaging sheet is manufactured of a material that is in widespread use. Therefore, winding a packaging sheet onto the core tube of the plaintiff's roll paper constitutes no more than the replacement of a consumable part under normal use. Therefore, the defendant's actions have not altered any component that constitutes the essential part of the invention. Thus, the defendant's actions do not diminish the identity of the patented product, nor do they amount to novel production of a patented product. Thank you. The court would like to ask some questions about these explanations. First, we have a question from Technical Advisor Takenaka, who is joining us virtually today. Can everyone in the court hear me? Yes, we can hear you. Please go ahead. First, I have a question for the attorney for the plaintiff. According to the evidence submitted by the plaintiff, the magnets used for the plaintiff's roll paper are extremely cost-effective ferrite magnets. What are the reasons for using such magnets? First, since each roll paper uses 4 magnets, we needed to use reasonably priced magnets. Second, although the rotation angle sensor on the plaintiff's roll paper uses Hall element sensors, if the magnetic force of the magnets is too strong, the Hall elements will be affected by the magnetic force of the multiple magnets. As a result, the precision of the rotation angle sensor will deteriorate. However, these magnets are sufficient for the job, and there is no reason to use more expensive ones. As a result, it is not conceivable that such magnets would be deliberately reused for a different application, and the recycling of the core tube can only be for reuse of the roll paper. Okay, next I have a question for the attorney for the defendant. The evidence submitted by the defendant describes the number of recycled core tubes and the number that were actually rewound and shipped as products. These figures show that almost 100% of the recycled core tubes were shipped out. The defendant also submitted provisional calculations of the differences in precision. There were no major differences, I believe. From a practical standpoint, is the precision of the defendant's product no different from that of the plaintiff's roll paper? Yes, this may be due to differences in the approach to the product, but the adjustment of braking force does not mean that the degree of roll paper rotation is changed continuously. Instead, it is actually divided into stages. As a result, even if the core tube becomes a little distorted, the difference in precision is never severe. I think the main difference is in user awareness. If the user is looking for perfect precision and wants to completely prevent tearing of the packaging sheet, a new product from the plaintiff can be used. However, if the user is not looking for perfect precision, then the defendant's product can be used. Okay, I see. Based on these questions and their answers, what can be said about the difference between the plaintiff's roll paper and the defendant's product from the technical perspective? From a technical perspective, there is no recognizable difference between the plaintiff's roll paper and the defendant's product in terms of technical functions. Therefore, the option of recycling, rewinding, and reusing the core tube of the plaintiff's roll paper, and the option of throwing the core tube of the roll paper away after use can both be regarded as natural from a technical perspective. Thank you. Next, are there any questions from the Associate Judge? Judge Motoyoshi has a question for the attorney for the plaintiff. The plaintiff argues that the core tube is not designed to be reused. However, according to the evidence submitted by the defendants, it seems that the plaintiff is also collecting the core tube of the plaintiff's roll paper. What are the reasons for this? This is simply because it is the manufacturer's responsibility to collect waste. When the user refills the device with new roll paper, we simply collect the core tube of the roll paper from the user, which does not require any particular extra cost or labour. So, are there any questions from the Judicial Research Official? I have a question for the attorney for the defendant. How many times can the core tube be reused? We cannot answer that question as we have not researched the number of times it can be used. Some users utilize the packaging device frequently and some hardly at all. The defendant has not identified the average time in which the packaging sheet is consumed. However, we have received no reports of the core tube breaking during the rewinding process. Okay. If there are no more questions, I would like to bring today's explanatory session to an end. Have both the plaintiff and defendant submitted every aspect of their arguments by this date? The plaintiff has no further arguments to make. The defendant also has no further arguments to make. In this case, I declare the conclusion of the oral arguments. The court shall render judgment based on the details of the explanatory session and the arguments presented by both parties up to this date. Judgment will be rendered on October the 17th at 2 p.m. After the oral arguments, the court recommended a settlement after hearing the intentions of both parties. The two parties held discussions towards reaching a negotiated settlement using the video conference system. However, the gap between settlement conditions of both parties was too large. Therefore, judging that it would be difficult to proceed with the consultations on the settlement conditions, the court decided to terminate the settlement procedure. This is now the date for rendering of judgment. The judgment is rendered orally based on a written judgment. Here, in consideration of this case, the court will read out the reasons and a summary, in addition to the main text of the judgment. Now, I will render judgment. Main text. 1. The defendant may not import or sell the products listed separately. 2. The defendant shall bear the court costs. I will now present a summary of the reason for this judgment. It may be construed that, in cases where a patent holder or a licensee assigned a patented product in country A, the patent right on that product has achieved its goal and has been exhausted, and the effectiveness of that patent right does not extend to acts such as the assignment of that product. This is because it is highly necessary to protect the free circulation of goods in the market. At the same time, it is not permitted to allow the patent holder to profit twice from the patented product, since the opportunity for securing compensation has already been granted. When a patent holder or its equivalent assigned a patent product outside country A, the patent rights in country A and the corresponding patent rights in the other country are separate rights. Therefore, it is not possible to argue in the same way with the case where a patent holder or its equivalent assign the patent products domestically. Also, in the light of the situation of international commercial transactions, when a patent holder or its equivalent assigned a patent product outside country A, it may be reasonably expected that the assignee or its subsequent acquirer will import the patented product into country A, and it is necessary to protect free circulation of the patented product. Therefore, in this case, when a patent holder or its equivalent in country A has assigned a patented product in country B, the patent holder shall not be entitled to exercise the patent right over the assigned patented product, unless the patent holder or its equivalent have agreed with the assignee to exclude country A from the areas of sale of use of the patented product, and the fact that it has been explicitly indicated on the patented product. In this case, the plaintiff's roll paper does not carry a clear indication that country A is excluded from the areas of sale or use. However, the objects on which the exercise of a patent right is restricted should be, in any case, the patented product itself that the patent holder or its equivalent had assigned to another country. Therefore, if this patented product is modified or a component has been replaced, and as a result, it can be regarded as novel production of the patented product that is not identical to the original patented product, the patent holder is entitled to exercise the patent right over the newly produced patented product. Subsequently, whether the modification or replacement can be regarded as novel production of the patented product should be determined by a comprehensive consideration of the characteristics of the patented product, the content of the patented invention, the manner of modification or component replacement, as well as the circumstances involving the transaction. The plaintiff's roll paper is designed to be attached to the plaintiff's device where magnets within the core tube around which the packaging sheet is wound are detected by the rotation angle sensor of the plaintiff's device. This enables the packaging sheet to be pulled out with the appropriate tension. If the packaging sheet is not properly wound around the core tube, the utility of the plaintiff's roll paper might not be fully realized. Therefore, it is expected to be used once and then replaced with a new one. Therefore, accordingly, the core tube of the plaintiff's roll paper is not designed to have enough strength for repeated use, and therefore cost-effective ferrite magnets are used. Therefore, the plaintiff's roll paper is not designed for users to remove the core tube and wind it with a new packaging sheet by themselves. Instead, users typically return the used core tube to the plaintiff for recycling and purchase a new one. In addition, the plaintiff's roll paper is exclusively intended for packaging articles. Once the packaging sheet is completely consumed, its core tube, the utility of the plaintiff's roll paper will not be fully utilized. Therefore, the magnets can longer play their technical role of the invention, even though they do not immediately wear out or break after a single use. Moreover, considering that neither the core tube nor the magnets per se possess versatility, it is unlikely that users will find any utility in them. From this perspective, the economic value of the plaintiff's roll paper is attributed to the packaging sheet. Based on comprehensive considerations of these circumstances, the plaintiff's roll paper loses its utility as a patented product once the packaging sheet is fully consumed. Therefore, the defendant's product, which recycles and adopts the plaintiff's used roll paper, adjusts the braking force of the packaging device in accordance with the external diameter of the roll paper, based on the position of the magnets installed in the core tube, to recreate the pulling of the packaging sheet of the roll paper at an appropriate tension, restores the material value of the invention. Thus, the defendant's product should be regarded as a newly painted product that is not identical to the plaintiff's roll paper. Therefore, since the exercise of the patent right of the defendant's product is not restricted, the plaintiffs may claim an injunction to halt import and sale of the product based on this patent right. Therefore, since the exercise of the patent right over the product is not restricted, the plaintiff may claim an injunction to halt import and sale of the defendant's product based on this patent right. Based on these reasons, the court rendered the judgment stated in the main text. This ends the mock trial. Thank you for listening. That is the end of the mock trial held by the team from Japan. Thank you to all the panelists.